It's the Drinking with Drew Show.
The only podcast in Florida hosted by the private investigator of the stars, Drew.
So, how's this coming?
Can you get this fucking stranger off my damn lawn?
I like it.
We're sampling drinks from across the world, but mainly from Riverview, Florida. We're giving you the spin on all the news you need to know about. Local, national, maybe even from your bedroom. Yep, that includes sex and whatever else we care to talk about.
I actually have a butthole in my face.
Better than Joe Rogan, but not as good as Jerry Springer. You'll laugh.
like I was on a safari and I got eaten by a lion. Like, fuck yeah. Like, you get to heaven, you got like street cred.
You'll cry.
I miss you. We still have it here, right?
You'll want to pry your earballs off. Tune in. Tune out. Don't believe a word we say.
That's so freaking cool, man.
drinkingwithdrew.com with guest Lusty Laura, the neighbor Joe, Darby, special appearances by J. Fred and Casey. And now, here's Drew.
Y'all better listen up now.
Hello, everybody. Today on the Drinking with Drew show, we have attorney Brian Szilvasy from the We Protect Consumers law firm, and he's going to talk to us about when you might need to hire an attorney for those annoying debt collectors. You're getting notices in the mail saying you owe somebody money. You're getting phone calls saying you owe somebody money. He's going to tell you some of the best avenues to help deal with those problems. So check it out. It's a great show, and it's coming to you from the capsflorida.com studio in Riverview, Florida. Talk to you soon. Check it out. So, Brian, talk to us a little bit about your firm.
Okay. Me and another attorney, my law partner, Art Rubin, we have a firm called We Protect Consumers, and pretty much all we do is basically help people that are being sued on old debt.
So these are the collection companies calling you 10 times a day and
Right.
calling you without permission, and
Mostly suing you on old credit card bills, store cards, automobile loans, signature loans, and so forth. So our firm's we have an interesting background because I did collection work in the state of Florida for 15 years and my law partner did it for 23 years. So we did all the quote unquote bad guy stuff. We garnished people wages, levied, did the collection work for most of the banks and most of the debt buyers in the state of Florida for many, many years. And then, at a certain point got burnt out and decided to flip sides. And we started the We Protect Consumers law firm about 8 years ago. And now all we do is represent the people that are being sued.
things not quiet at all.
Yeah,
But you can grab me one while you're on.
If you want to hear the 2-minute spill on how all this works.
Yes, go ahead.
So this is hypothetical, right? So you owe $2,000 on your Home Depot Citibank card because Home Depot doesn't have a bank. So if you look at the back of your Home Depot card, it says Citibank. And then you get in a car wreck, you get sick, your kids get sick, you get divorced, COVID happens, hurricane hits Florida, you name it, you stop working, and you can't make your $50, $60 a month payment. You call the bank and they don't care, they want their money. So they run it up for 6 to 7 months with high interest late fees, and your balance goes from $2,000 to $2,800. And then at that point, the federal government requires the original bank to accelerate and charge off your account. So now that 6, 7 months later, they want $2,800 when you couldn't afford to pay the $50 to $60 a month for 6 to 7 months, and 99% of people can't afford to do that. So what happens is, and you probably have 6 or 7 of these because nobody just has one credit card. So then they pursue you usually for another 6 to 24 months. And then what happens about 2/3 of the time in this country is that original bank will go, we don't want to pursue this anymore. So they'll package it and do a forward flow agreement and sell it off to a debt buyer. And most of these companies are buying this stuff up at about 3.5 cents on the dollar, and they're buying tens of millions, hundreds of millions of accounts and paying 3.5 cents. So if you owe them $3,000, this company's paying about $100-$105 for your account, and then legally can assume all the rights and obligations for the whole account. And then what happens in Florida is they turn around and sue everybody, kind of like a shotgun approach. And of course, there's going to be some people that file bankruptcy, some people are deceased, some people they'll never find. and then they'll get a certain percentage of people that'll voluntarily enter into repayment plans and so forth. So
what makes a person a target to go after more so than somebody that doesn't? Like, let's say you have somebody that rents a home
heartbeat
versus owns a home.
It used to be like that. I mean, and to be honest with you, I mean, when I first got into this field in '99, and they still do it to a certain extent. They would do what they call scrub. So you would look for home ownership.
Yeah, no scrub.
Yeah, you'd look for home ownership. Obviously,
right.
That was always the thing. And then 2008 happened, and now there's more renters than whatever. And it's just so. Unfortunately, it used to be that way. You'd look for someone that had a home ownership, had a stable job, and so forth. But now the stuff is so cheap and being sold for so cheap, because back then you would maybe pay 20, 25%, 30% of the debt, because you're like, okay, I'm getting it for a third or 25%, and I'm going to go collect this money. Call it scoring. You got some mathematician guy or accounting guy that comes up with some scrub software, and he can evaluate it, and you pay the guy a couple of grand, and I say, I'm thinking about buying this portfolio, and they want 2.5 cents on the dollar. Can you scrub it for me? And he'll go through it and he'll score it and tell you whether, it's a projection on how much he thinks you'll be able to recover on it.
Right.
Because nobody's just going to give you pure, all these guys got, before this happened, had 800 credit scores. It's all lawyers, doctors, and whatever. So, of course, here in Florida, you get a lot of people that are on Social Security and so forth as well. But the main thing is the fear of the unknown. And that's how we get to our practice. And it's a big thing here in Florida. So there's probably about anywhere from every single week in the state of Florida, maybe other than Christmas week or something like that, Thanksgiving, there's about 800 to 1,500 of these lawsuits filed every single week from Escambia, from Pensacola to Key West. So we send out a letter, and we don't even handle half the stuff, okay? It's just too vast.
Right.
So we send out probably between 600 and 1,000 letters every single week to people that are being sued on these types of debt, offering our services. And we offer a free consultation, so they could call in on our toll-free number. We'll tell them, some people like, I don't know what the heck's going on. I don't know what this is. I've never heard of this company before. That's all true. Because we'll know, most of the time we know about the lawsuit before they do. Because what happens is, if you're sued in the state of Florida under a small claims case, that means $8,000 or less. What happens is, when the lawsuit's filed at the courthouse, the clerk of the court assigns a pretrial court date, typically 6 to 12 weeks out, for that person to come live in person or now by Zoom or whatever. So the judge could talk to them and ask them, do you owe this debt? Because it was always made that small claims court was originally supposed to be between neighbors or relatives, or small loans where two people.
Now, are they including medical bills now?
Oh yeah, anything.
It used to
matter.
Not be medical bills.
It can be anything that's 8,000 or less. So yeah, medical bills, you name it. So cell phone bills. The problem is, comparatively speaking, Florida's cost of filing a lawsuit is rather high based on the national average. There's some other states where it only costs $95 to sue somebody. Okay. Here in Florida, it's like zero to 500, 500 to 2,500, 25 to 5,000, and it kind of goes up there.
It's those process servers that charge so much money to serve.
Bastards. Yeah. You want a pluries? Great.
So go ahead and give us your website and your phone number.
Yep. So we're
right here.
Yep. WeProtectConsumers.com. Our toll-free number is 1-800-813-6086. Open pretty much Monday through Friday. If you call, you don't reach us, we're probably in court. Leave us a message and we'll call you back. But we offer a free consultation to everybody. Obviously, there's certain people that can't afford to hire us at all. There's certain people where it doesn't make any sense for them to hire us. We forward people onto, bankruptcy attorneys sometimes if it's just too far gone. But typically, we're able to get involved in these, probably 90+% of these debt buyer lawsuits. And because of our experience, because of our knowledge, and because these other firms and these other attorneys know us, that we're typically able to get our clients out where they don't have to pay anything, or maybe they pay a few $100. So it's a great thing for for the people that can afford to hire us. But the problem is the banks and the debt buyers, they know people are dealing with hard times. Always called it, even when I was.
Can I pay by credit card that I don't plan on paying?
Yeah, pretty much. Pretty much. Yes, we take.
I've got a new case coming for you.
Savings, debit card, or credit card. Exactly. So yeah, we do take those form of payments, but you know,
You don't deal with IRS debts or liens or anything like that?
no, that's specialized. We do help people with garnishments of banks and their wages, but you know, student loans is very specialized. IRS is very specialized.
I owe a prostitute like $500. Can you help me out with that?
I'd probably just say pay her.
Why you just assume it was a her?
Yeah.
Well, you know, I'm trying to give him the benefit of the doubt.
It sounded like a her. I didn't know, you know.
Yeah.
Could have been you, Joe.
Laura will probably kick in half, just you know,
Probably.
give her a night off or something. Right?
She's the one I owe fucking money
well,
to.
I would definitely.
We
pay
have
her.
this
would-
role-playing thing going
I
on.
You
would,
remember when we were talking about your COPD, and I told you it's
Right.
probably Laura holding the pillow over your face
Yeah.
while you're trying to sleep.
No, I would pay towards a hitman, not to pay off the prostitute. Yeah,
there you
find
go.
out. Yeah, hitman.
So
Why pay someone you can do yourself? Come on, Laura.
She's got weird skills.
So
if
most
somebody has let's say, you know, like $1,200 medical bills that say collections, what are the odds they get sued?
it just depends. I mean,
Yeah.
pretty high, unfortunately, here in the state.
Yeah.
I will tell you, in general, medical bills. You know, if it's outrageous, I mean, you know,
Like $100,000 or something.
yeah, I mean, at a certain point, you may just file bankruptcy or
Right.
just tell them you can't do it. But in general, what I can tell you is the hospitals, if they're doing, a lot of times they'll do their own work, or they'll have someone in administration that'll file a lawsuit or reach out to somebody. My personal opinion, they've been very, very lenient on people. If you're honest to them and say, we're in hard times, my husband had a heart attack, you know, after insurance and whatever, we still owe you 10 grand and we're both on Social Security. I've seen them go, well, can you pay 50 a month? And they're like, well, yeah, we could pay 50 a month. They're like, okay.
Yeah.
So they're more reasonable. Cause I'm sure they're writing a ton of it off,
Oh yeah.
you know, and the doctors just want to get something coming in. Two things about that in general though. Okay. Everybody has what they call a statute of limitations, right? So pretty much everything other than maybe like criminal stuff now they keep extending has a statute of limitations, which means how many years after the act or someone becomes aware of an act or a cause of action that someone could sue you or you could be sued. Because they want people to be able to not have to keep looking over their shoulder
Right.
for the rest of their lives. So in Florida, if it's a kind of like a credit card or store account kind of situation, it's 4 years statute of limitations. If it's a written contract like an auto loan or your rental agreement or a mortgage contract or something like that, it's 5 years for someone to sue you. So if you default, you know, voluntarily, involuntarily, whatever it is, and someone calls you in 2 years and says, hey, Joe, this is Jim with ABC Collection Agency. You never paid this gym membership, or you never paid, you know, this medical bill, or you never paid whatever, and we just want you to reestablish contact with us. Can you just pay $50 today towards this? And you're like, yeah, man, I owe like $5,000. I'll pay 50. Well, if you make that voluntary payment,
You're committed.
you just started the 4 to 5 years
right.
all over again.
Yeah.
So I always tell everybody, they always ask me, we get a certain percentage of calls where people go, I can't afford to pay anything. What should I do? What can you do?
Yeah,
I mean,
right.
if you can't afford, I can't afford to hire you. I can't afford to pay. Well, then you grin and bear it. And then, and if they go and they sue you and they get a judgment in the state of Florida, they do have up to 20 years to try to collect. That shocks people sometimes.
20 years.
Yep, 20 years, and there's a statutory interest rate that's somewhere around like 6.5% that gets updated every year. So there's an interest rate that's accruing on it. So,
But they can't take your house. They can put a lien on your house. They
right,
can,
they have limited things, and look, there's and I always tell everybody there's two things, right? There's legally what people can do, and there's what is likely someone's going to do. Okay, and the difference of that is, you have to understand that most of these attorneys get paid off a percentage, right? So they're making 25, maybe up to 50% of whatever they recover. So if I sue you for $1,500 and I get a judgment for that plus my court costs, now you owe my client $1,800, and I find out that you have a $10,000 Harley paid off. Even if I wanted to come out and get it, I have to put up double bond for that. I have to pay the sheriff's deputy to come out here, impound it, haul it off, store it, notice you for auction, have an auction, pay everybody's fees, and if I net, at least $1,800, then I get my money. And that attorney, if he's on a 4% or 25% contingency, makes $450 putting up a $20,000 loan and doing all of that.
so the secret in life is never pay anything off.
Pretty much.
Yeah.
You know, if you lease, if you rent, you know, we call it, I hate the term, but people say, are you judgment proof? I don't like that, because no, you're not judgment proof, because you could still get a judgment entered against you, you know, and if your parents pass away and you come into land or you come into money, then that's an asset that somebody could get during that 20 years.
They win the $1 billion on Wednesday.
Exactly. Pay off everybody's debt. But that was one of the funnier shows, though. What was it? I'm going to forget what it was, but he was making fun of it was the British guy TV show, and he was making fun of Oprah, and they went out and bought like $100 million worth of medical debt at like 3 cents. And he pushes a button. He hired attorneys to basically absolve all these people.
Oh, wow.
Because he did the inverse. He bought it to free all these people from the medical debt.
Yeah.
Wow.
That's awesome.
Come on, Elon Musk. Help us out.
All right.
Exactly. So I know you asked, so let me finish with this.
Yeah, go ahead.
You asked what they can do. If they get a judgment in the state of Florida, the main 3 ways for them to collect is, 1, ask you to pay. And they could be rude about it to a certain extent. They could call you, write you, and I call it that, the small a aggravation, right? And a lot of people voluntarily pay because they just don't want it over their head and quote unquote want to do the right thing. The other 2 main options is wage garnishment. If they find out where you're working, they can serve a wage garnishment on you, and your employer withholds 25% of your disposable income. Okay, so that's a lot of money.
Mm-hmm.
There are exemptions from that. One main one being if you're head of family.
Garby.
So if you provide more than 1/2, and the primary easiest example is if you're in a primary wage earner of a nuclear family, and you have kids under the age of 18, because there's only one head of family. So
I'm going nuts.
If it's just you and your spouse. So yeah, so basically, if your wife does not work and
you're set.
It's just you,
Garby's smiling so much right now.
You could go out and run up a whole bunch of debt and default on it, and you're
He's got
saying,
his mental pamphlet
yeah,
going.
you can't do anything to me, or limited stuff. And then the last thing is bank garnishments, where if they find out where you bank, they could try to freeze your bank account.
Now, is that personal? Is that personal accounts, business accounts, anything attached to you, or is it just only personal accounts?
It depends, really, to be honest with you, a lot on how the bank treats it. You know, technically, there's supposed to be a bifurcation between the individual and their business accounts, but depending on how you have them set up, I mean, I've had people, when I was on the other side, call me freaking out, going, yes, I owe you this money, but you just froze my payroll account. I said, well, understand, I didn't do anything. I got a writ served on your bank that said freeze anything that has his name on it. And if the bank or the bank's attorney freezes stuff that's on your business, that's between you and them in the court. That's not nothing to do with me. So I've seen it done before. I don't think, like I said, I think if you have your account set up, a lot of people, what they do is, right, they incorporate, and then they go down and they open an account and they just put it like DBA. Okay, well, that's you, man.
Right.
You know. So the bank, all they're going to do is say, hey, they turn it over to the attorney. The attorney looks at the way the paperwork's filed in the court, and if there's not a clear delineation between you and your business's accounts, they'll freeze those too. Now, you get a right to have an exemption. They send you out paperwork, and you can file an exemption. That's why I say it's frozen, not taken. Because if you file the exemption, then you could go into the judge and then you argue whether it's your money or not your money and all this other stuff.
There's so many people, I think, that are probably, COVID, I'm sure, made it so much worse. Did you notice business just for you kind of going nuts after, or maybe it's not even reached that point yet?
Yeah, it usually takes, I always tell everybody, I mean, we're busy in good times, we're busy in bad times. I really don't see it really going up and down that much usually. A lot of it has to do with how the businesses are doing, how the debt buyers are doing, and how the law firms are doing. If they're doing okay, they're filing more. If they're sucking, then they're not putting out more money.
Some cases that I was helping you with were your clients that you helped, and then they moved, and you couldn't get in touch with them to help them out with their, like, to give them notices of their cases.
Right. When we first, what you helped us with was when we first switched sides. The people now are getting, the last 6-7 years are getting the benefit of a lot of the work we did. You put a lot of energy in a sense, beating these guys up. So then you're like, hey, you knew who we were. You didn't want to play ball. We're going to drag you through the court system. And then when we beat you, we're going to cost you tens of thousands of dollars. So next time, instead of making us do this and us duking it out for 24 months and costing you all this money. When I get involved, I can take a small fee from my client. You'll go away. My client won't pay you anything or pay you a couple $100. And it's kind of like a win-win. It's kind of mutually assured destruction thing. So what you helped us with is we had at that point, we had 87 cases where we had won, and we were seeking prevailing party attorney's fees. And we had gone to a mediation where we were trying to mediate to settle them all at the same time,
Right.
which we did. And because this had happened and had all these cases on average were somewhere between 2 and 4 years old at that point, we're like, okay, we're getting 87 individual settlements that we need our clients to sign to resolve this so we could get paid our fees and their case would be completely over and they would get it. Their case, we'd already won their case, but since it wasn't a settlement, it wasn't off their credit. So this back end deal was to get it off their credit and get us paid our fees by the debt buyer we'd beaten. And so we ended up, I don't even know how many it was. Was it like?
It was a ton.
Yeah. So at a certain point, after like 2 or 3 months of sending emails that were bouncing, calling any numbers, doing a little of our own skip tracing, I gave you a call and I said, we need to find these damn people or we're not going to be able to finish their stuff and we'll probably end up having to withdraw. And I think you found probably 95% of them.
Right.
I mean, I think 1 or 2 of them, you had to sit there and they're calling me, who's this guy that keeps leaving stickers on my door? I'm like, I'm your attorney. You call me, ding-a-ling, you know.
Yeah. I think a couple of them had died. Who knows?
Yeah, I think we had 2 that passed away, and luckily we called the other firm and said, hey, they expired. We're going to sign. I called their estate, their family, and they said, go ahead and sign. And luckily they weren't, you know.
But that's surprising, though, because even with personal injury cases, I get attorneys that call me and say, hey, my client disappeared. We have a settlement. We're ready to go, and we can't find our client anymore. It's like, they just stop communicating. Like the attorneys are trying to reach their client, but they've moved. They didn't forward the phone numbers, whatever. And you just can't find these people. And they're like, hey, I need you to find my client. It's just like, okay.
Yeah, that's what I don't understand with like our clients. When you have an active legal case, whether it be collections, family law, whatever it is, if you provide an email address and you've been communicating with your attorney, like, keep checking your email. Like, I can't stand when I have spam in my email, so I check it at least once a week to clear it out. But it'll be months at a time where we don't hear from clients, and I'm like constantly trying to like.
Wow.
Yeah,
I can
it's just
tell
crazy.
you. I mean, we get settlements. You know, we're a high volume business, so we get settlements almost every single day. Like today, I probably got 6 to 8 new settlements, and we use the system for e-signing that I send out. And I can almost guarantee you by tomorrow morning, at least 4 of them won't even be looked at. So we have it where it repeats sends every 24 hours to the person, depending on what's going on with the case. And if they have a hearing come up, I'll either wait a couple of days, but then at that point, I'll start calling them. Half of them have, once again, I call it ostriching, right? When you quit paying all your bills, everybody's calling you, you're going to have a stress heart attack. So you ostrich, you stick your head in the sand.
Right.
Well, guess what? You're not taking the good calls or the bad calls. So there's all these systems that'll hang up on you. They'll do all.
When
this
Laura
other
starts
stuff.
yelling at me, I ostrich.
So I'll even text them, and they're like, "Who's this? This is your attorney." Well, who is it? Well, look at the first text I sent you. I said, "Hello, this is Attorney Szilvasy, your attorney with your ex case with a law firm that We Protect Consumers. We've emailed your settlement the last 7 days. Can you please check your inbox and spam folder?" And I can tell you probably 2/3 of those guys come back and say, I never got it. And then I take a screenshot on my phone, not screenshot, but a picture off the laptop and send it to them. They're like, yeah, that's my email. Okay.
Check your fucking email.
Yeah, check your ban. It's not in my trash. I didn't say trash. I said spam. Those are 2 different ones.
Now, with all these things going back and forth and everything, like $2,000, $3,000, is it really worth the effort for such little dollar values?
It's
and just so much volume, just clogging up all this paperwork and whatnot. I don't want to say your business is not valuable. I don't know, like, what's the threshold of what's important or not?
Based on all the traveling he's doing, I'm thinking it's worth it.
Oh yeah, from his perspective, yeah, and he's providing
that steak he ate last night.
He's providing a valuable service, protecting little guys from the big giants.
Right.
But I'm saying is from the big giants' perspective, from these companies, is it really worth it to go after someone for like $2,000?
Yeah.
Yeah.
I mean, they wouldn't be doing it if they weren't making money. Remember, to start off with, if it's a debt buying case, they only paid $70 for that $2,000 case.
Okay.
Then they pay the court about $230 to file. So they only have whatever that is, $300 into it. So, and then they don't pay the attorneys anything. Okay. If I hire you as a law firm, I'm like, I have this debt. I want to hire you to collect on it. And you get two things, right? The first thing is you have to front all the court costs and then bill me quarterly. And two, you only get paid if you collect money. So if you collect the $2,000, I'll give you $500 of it. If you don't collect anything, it didn't cost me anything, other than in 3 months I have to pay you back the court costs you funded. But I would say probably 70% of the cases that we see are between $1,500 and $3,000.
Yeah, not just for the reasons you mentioned, but also if that threat's not out there, what's to stop everybody from just not paying any debt under $3,000?
Yeah. Is there any opportunity for maybe automation or optimization of the overall process? Because it seems like there's a lot of paperwork and a lot of back and forth, and you got to hire an attorney, I got to hire an attorney, then collectors. There's so many people involved and so many hands in the pot.
Chat GPT.
Is there some sort of like?
Well, it already has.
Like if there's some sort of like central clearinghouse that you kind of just everybody put it in and then.
Well, they
Put it in.
They have done like one national collection agency, Man Bracken. Usually, what happens is unfortunately somebody ends up running in afoul of something, or somebody finds a technical deficiency in something. So, if you're a medium-sized business and you make a medium-sized mistake, maybe it costs you $150,000. If you become I'll keep using this firm name because I don't even know if it exists anymore, but there was this company named Man Bracken, and they were trying to take over basically collections nationwide. And when an attorney found a problem, which a court found that there was a technical issue in one of their letters, and these guys were probably sending out 30,000 letters a week.
Oh my God.
Okay, so that's 1,000 per letter. So that's 30,000 per week. There's a 1 to 2 year statute of limitations. So do 25,000 times 52 weeks times 2, and then basically whatever that amount is, the attorney's fees are probably 3 to 4 times that. So what I've seen is it's kind of like the fat calf or whatever that approach is when if you get too fat and too big, then you become a target. So for the most part, and it's the same way with regulation. If you're a small cat, even if maybe you don't have all your license or all your T's crossed or your I's or whatever, and you're under the radar, you're not that big of a deal. But all of a sudden you become Andrew Tate or Mr. Beast or whatever, and you start making all this big bucks, then you're going to have the IRS, the federal government, and everybody looking at you more closely. So I can tell you, even when I got into it, I still saw the first firm I worked for doing collections, they were originally getting like 50 cents on the dollar, okay, for a lot of this stuff like Ford Motor Credit, Daimler Chrysler, GMAC. And then what they realized too is that, there was already automation starting 25 years ago. Everything at one time they were taking all the statements, boxing them, and shipping those to the firm. Think of how crazy that is.
Right.
Then we thought it was such a big thing to get it on like hard drives or zip drives, so then we could download it to our system and see it. And now all you do is basically send it in an email. It's an attachment.
I did have an attorney drop off 500 pages of documents at my office today that didn't. I don't know.
It was probably like 200 pages.
Oh, okay.
Well, in discovery and stuff, you still have to do that to a certain extent. But some of that's
Discovery.
Good luck.
One of my least
Good
favorite
luck
words.
finding it. So I mean, we have our system fairly automated. Like we went remote before everybody else, before COVID and stuff, because we don't necessarily meet our clients. We don't need to. That helps us keep our overhead down. So if you want to hire me after you get your free consultation and I explain what I can do for you and what your projected outcome is, we even offer a refund if we don't obtain that result for you, which is kind of insane. So we send you over the contract for a digital signature for you, and then we send you over, if you're paying us a fee, then we send you links for you to pay us our fee. And like I said, probably 95% of our cases are done within 4 to 8 weeks.
Wow.
We
do, you
have,
have, do you ever have clients that want to meet face to face?
on occasion, yeah.
What do you do? Just like meet up at Starbucks, or do you
No, I mean we actually have 2 shared office spaces. Like still down with
okay.
John, we kind of have a deal with John that we can use this conference room, and then we do have an office space over in Orlando as well. To be honest with you, I think the last 2 people that have asked to meet in person, I just passed on their cases.
Right.
Because at a certain point, after I spend an hour with you on the phone, we send you reviews. You could go see our reviews. A lot of people, and understandably so, they're afraid of getting ripped off.
Sure.
And I said, look, we're not a business. If a business rips you off, you have basically what? 2 things. You can go and smash them on a review, smash them on Better Business Bureau, or sue them, which most people, it's not worth suing someone over a few $100 or $1,000. If an attorney steals from you or does something wrong, you could report them to the bar where they can either be suspended or disbarred from practicing law. And there's an actual fund that the Florida bar has to actually repay funds that are literally stolen by attorneys. So when I tell them that, it depends, but yeah, I think over like the last, of course we weren't meeting anybody during COVID.
Right.
And I think the last 2 or 3 times I met somebody, I think it was because I was interested. One of my clients was actually a person that had immigrated from Hungary and wanted to meet me. So I actually went into John's office to meet them just because to meet somebody else that was from Hungary. But
that's crazy though. Those personal injuries, some of those personal injury attorneys that are holding, their clients' money for years and not paying them. I mean, that's
Right.
I mean, so I understand where people who don't understand the process are concerned, but
we're like typically our clients, 99.9% of the time, our clients are the ones that are being sued. They allegedly owe money. So they're paying us a flat fee to do all this work for them. Like I said, most of our cases are probably done within 3 to 6 weeks. Rare is it that it goes past 8 weeks. So it's really kind of a fine-tuned machine. The other side knows that they're either not going to get anything out of it, and they don't waste. When people really drill down and they go, okay, can you give me 2 examples? Now, understand everybody goes, you remember the disclaimer, this is not a typical result. Right? So when we had first...
I tell that every time me and Laura have sex.
Yeah, this is not a typical result.
It's written on our walls.
That's all the weight loss claims.
Exactly. So we had a guy that had gotten sued down in Bradenton for $1,500 and $1,800 when we first switched sides. And we reached out to this firm and said, hey, you know who we are. Here we come. We just want what we call in the industry a mutual walk, which means my client's not paying you. We're not asking you to pay us any attorney's fees. Everybody just releases each other and goes away. And this guy was upset. This firm was upset that we'd switched sides. We got threatened when we first. You did something illegal. No, we didn't. You could switch sides. You're at the public defender's office. You can go to the state attorney's office. You're at the state attorney's office. You could go and become, criminal defense attorney.
You can go from law enforcement to defense.
Yeah, you could bounce back and forth. The main thing you can't do is you can't work on the same case that you had viewed. You can't view the evidence and go,
or this is like a Garvey's experience. You can go from straight bar to gay bar. I mean, it works in all kinds of weird ways.
So you could bounce around. But we were threatened. So anyway, this guy didn't want to work. He goes, no, we're going to fight you. And we're like, okay.
I already know all your tools.
Yeah. So we fought for 10 months and actually won the case. Not settled. We won. So our client didn't owe the $1,500 and $1,800. And then, so we said, okay, we prevailed. We don't have a settlement. Now you owe us attorney's fees. And he goes, go jump off a bridge. So we fight him another 12 months on fee entitlement. We have to go through this. Judge finds us entitled and enters a fee awards on the small case. Remember, $1,500. So let me give you the facts. So if they sued him for $1,500, remember how much did they pay for that debt?
Like
about $50.
Yeah.
If that, $52. Okay. Yeah. So they didn't get their money, and then the judge gave us $20,500 for the $1,500 case, and $24,500 on the $1,800 case.
Well, you spend almost a year and a half on the case.
Right. So they got an award that they had to pay us $45,000 on basically $3,300 worth of debt that they'd basically paid maybe $100 for.
So is it really worth it for them to go after you for $3,000?
Well, it is because
If
most
it doesn't
people
go that way.
don't get attorneys.
If you lay down and pay
And
it,
just pay 'em, yeah.
They play the odds. Now, the business model has gotten a lot tighter because before the proliferation of the internet, nobody knew of this stuff. Nobody knew that attorneys will defend you. Nobody knew that you could not pay them. They just figure, you'd be surprised 20, 25 years ago, someone would walk in and say, oh, I don't want to go to jail. Well, I can't tell them, pay me or you go to jail. That's illegal. I go, I don't know if anybody wants to go to jail. I didn't lie to them, but I'm not their attorney at that point. I don't have to tell them they're freaking out over nothing. That, their thoughts and freak out in their own head makes them more likely to pay me if I'm the collector.
right?
So you do stuff like that, and then, yes.
Is it one attorney fees if somebody owes like 4 or 5 creditors, or is it 4 or 5 attorney fees for every creditor that they're trying to?
It's per suit.
Duck.
Yeah, it's per suit. So if they attach, and that you'll see that every now and then, they'll attach 2 or 3 or 4.
But like
accounts.
Synchrony Bank owns
All
Everybody.
credit cards.
everything.
Everybody. Yeah.
So
So
it's
they
like-
could. So if Synchrony Bank sues some of their stuff, and they sell a ton of stuff as well. So if they sell it, let's call out some companies, Midland Credit Management or anything that's Midland.
Midland.
They're one of the big ones. Portfolio Recovery, another
Oh,
really
Big one,
big
yeah.
one.
yeah.
LVNV Funding. Okay, they're big in Florida now. Calvary SPV,
The worst.
Jefferson Capital, Credit Corp.
So basically anything on my blocked numbers list.
Yeah. Look, if you don't recognize it from a billing statement or something like that, or you get a letter saying that we now own your debt, that is basically a debt buyer. Anytime it's charged off, meaning it's gone bad, and then someone comes along and buys it for pennies, they're the debt buyer. So they buy this stuff cheap. They sue 100 people. Maybe 5 or 6 of those, 7 of those people go out and get help. There's a lot of companies where these people aren't attorneys, because anybody can basically become a debt negotiator. So you could send the same letters out that I'm sending. You can't file a legal appearance, but you can say, hey, pay me $150 and I'll call and negotiate on your behalf. And so, they call me and I say it's $400, but I'll get you out of it. But if they don't call me and they call you, well, $150 ain't bad. And they call you and you call them, and you know, a lot of these debt buyers will give you 60-70% settlements because they got 3.5 cents into it, or they'll set you up on a 3-year repay without you having to hire anybody, and you're like, well, that's a lot more generous than the original bank was telling me or what they wanted to do. But back to your question on Synchrony, if they sue you 5 times and you get an attorney for each case and you win all 5 cases, then you're the prevailing party, and the judge in each case would have to make a determination to entitlement one.
Well, it seems like if you won one based on circumstances, you would win the other ones because they're all creditors, and
It depends.
you're winning based on the same
you would
circumstances,
think,
right?
you would think. But, you know, we're all fallible, we're all humans, so a lot of it depends on what kind of judge you're going in front of.
Do you have any advice for the consumer as far as, do you negotiate with the bank? Do you try to negotiate with the debt buyer, or wait until it comes to that point where they've sued you?
His advice would be get an attorney.
No, I'm saying, no, from the beginning, like,
Look, and I tell
because
everybody,
it's a long time before it actually gets
Right.
to a debt collector.
Yeah.
well,
I
not
mean, the
always.
bank
Usually-
has reached out to you.
Yeah,
then,
usually it's like you were saying about how long it gets, you know, am I seeing stuff from COVID? Yeah. It's on average about 18 to 24 months. It could go longer than that. So, yeah, we're seeing COVID debt
Right.
now, a lot of COVID debt. I always tell everybody I don't have a crystal ball. If I had a crystal ball, I'd win this damn Powerball thing tomorrow night or whenever it is. And I would have won the one a year ago, and I wouldn't even be on this show.
$2 billion.
But what I can tell you,
Come on the
yeah,
show.
I wouldn't be on this show, right?
You would star on the show
Right.
nightly.
I'd have my own show.
You would donate to improve my studio.
That's right. I'd sponsor it.
At least the sound.
It'd be We Protect
He couldn't even
Consumers
afford
Studio.
pizza tonight either.
Oh, Lord.
It would no longer
He
be
had to
the
serve his balls.
it would no longer be the capsflorida.com studio.
So this is what I tell everybody. I said, I don't have a crystal ball, so I can't tell you whatever. But so we only deal with what's in front of people. I always tell people, if you can afford to pay your bills, pay your bills. If somebody offers you something that you think that you can do without starving yourself to death, and you think it's the right thing for you to do, then do it and live with the consequences. If you can't afford to pay it, you know, then you roll with it. What I can tell you is if you're receiving letters now, anybody that's viewing or listening to this, and you're getting letters from some of the businesses we're talking about, the debt buyers. They're saying they bought the debt. It's not Synchrony. It's not Capital One. It's not American Express. It's not Discover. Any of these guys. LVMV Funding, Midland, Synchrony, not Synchrony, Calvary, Credit Corp, Jefferson Capital, any of those that are debt buyers, most likely if you owe them more than $500, they're going to sue you. You can either try to work out a settlement with them before, you can call our firm and discuss it, if you get sued. What I can tell you is we're not the only ones that do this kind of work. Typically when somebody gets sued, they'll get anywhere from 10 to 20 letters. Now, not all of them are attorneys. Some of them are debt negotiators and bankruptcy attorneys and stuff like that. So if it's another thing, a bit of information is check your mail. Because what will happen a lot of times is if Synchrony has it and you owe them $2,000 and they're about to sell it to somebody for $75, they may send you a letter and say, Joe, give us $500 in the next 20 days and we'll call it scratch. That's a heck of a deal, and if you can afford to do it, like I said, I don't have a crystal ball, but pay it, and then you're done with it. No. You don't have to worry about being sued. You don't have to worry about if the debt gets sold.
That was what the advice I was asking for.
Yeah, you don't have to worry about peace of mind is a lot in this world. So if you have the ability and someone offers you what you think is a fair deal, don't be afraid to take it. 2 caveats to that. 1, don't pay anybody anything until you get it in writing. Okay, so someone says if you pay right now, we'll take 25%. Well, Jim, that's great.
Send me the
letter.
Here's
my
first.
email.
Don't give them a credit card over the phone bullshit.
Right. Send me the letter. Let me get the letter. Look at it. Give me your number and your extension. As soon as I get this and I take a look at it, I'll call you back in 10, 15 minutes and we'll get this wrapped up. But you called me. I don't know. You could be calling me from Zimbabwe. I honestly don't know. So before you pay anything, get it in writing. Mail to you, email to you, faxed.
Is it true that if a debt collector calls you and you tell them that you have an attorney, they have to stop calling you?
To an extent, yes. Really, you should be able to tell them who your attorney is because they have to know who to call. Okay?
So you have to give them the name and the contact information.
Yeah, you should. If you really do have an attorney, this is the thing. A lot of times people hire bankruptcy attorneys, right? So you have an attorney. But you're not paying the attorney to handle that debt issue. You're paying that bankruptcy attorney to discharge all your debt. So I can't tell you how many times they're like, oh, I got attorney Lewis and Jernevoy. Well, they're bankruptcy attorneys. Yeah. Well, they're not going to go to court for you. Oh, yeah, they're handling it. They don't show up in court because they don't care about that individual case. They've got it all mushed into one. So the answer to your question is yes and no. They'll probably poo their pants when you tell them that to a certain extent because you're probably talking to a collector and say, then they'll ask you, who is this? And then if you can't tell them who it is, they'll eventually send you a letter that says you advised us you have an attorney, but you did not advise us who that attorney is. If you don't advise us in the next 10 days who this attorney is so we can reach out to them directly, we're going to presume that you don't have an attorney and resume collection.
Gotcha. So what if you have a debt collector? Debt collectors also sell their debt. Is that true? So if a debt collector buys the debt from a credit card company and they've been working on it for 6 months, a year, 2 years, and they decide, fuck it, we don't want it anymore, they can sell that. The debt collector can sell it to another debt collector and it starts over a new term, or they start over. Is that not true at all?
No, there is no new term. I don't know what you mean by that.
Well, because I was told that a debt collector can sell it to sometimes even a competitor.
Right. Well, you're intermingling terms. Okay. A debt collector is anybody that collects a debt.
A creditor.
A debt buyer is somebody that buys the debt.
They can sell that to another debt buyer.
Yeah, you could sell it as many times as you want. There's people out there.
That's what I mean. So if that happens, let's say I hire you and I'm like, look, I got this debt I need to take care of. They're calling me. And in the meantime, we're dealing with this. They sell that to another debt buyer. And now do I have to open a new case because the debt buyer that we were dealing with, they're done with? They're like, fuck it, we're no longer wanting to deal with this. And now I've got another debt buyer, the same debt, different technically different
Well,
plaintiff.
they'd have to refile a new lawsuit
right,
against you.
right. So,
they
but
would sub in basically. That really rarely happens. But if they sued you and the case was going on, and they sold the account, then that new debt buyer can just do a sub in. We've bought the debt. Here's the bill of sale. We're subbing in as the new plaintiff. Then motion to amend and change plaintiff name. Now.
same case number though. Same court case.
Yeah.
Okay.
Now they don't have to. I mean, if the old company dismisses the case, then your attorney's the prevailing party and will be entitled to prevailing party attorney's fees from the first company that dismissed it. So you can't get out. You can't get out of a lawsuit by just selling the debt and going, "Ha, let me bail out of this." You know, I mean, especially during like 2008, 2009, you had whole banks being absorbed.
Right.
Yeah.
You know, whatever. So you'd get something and go, "Oh, the statements just changed names. Did you sell the debt?" Technically, we sold the whole bank,
Right.
or we sold the whole credit card division of the bank. So that's happened before. And you've had companies change names, like you had GE Financial Services that then became Monogram Bank of Georgia, who then now became Synchrony.
Right.
So there's, so you can have name changes, you can have whatever. But when you were saying start over, I didn't know what you were talking about, the statute of limitations or the lawsuit. But technically, if you sold the debt,
But as far as me hiring an attorney to challenge that, am I hiring you? Would I have to pay additional fees to hire for the same debt?
No, not if it's still within that lawsuit.
Okay.
I mean, like I said, that would be. I don't think if I've seen it, it's been super, 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 super rare.
Okay.
But typically, would you say it's typical if a debt collection company is selling its pre-lawsuit, like once they're in a lawsuit, they're kind of writing it till the end. They don't really sell that often while they're in active litigation. It's kind of like still sending collection letters, making phone calls, trying to do it before you enter the court is when they'll go ahead and sell a debt if they can't collect on it.
Right. Yeah. Once someone sues, I mean, you have people that sell judgments. So they sue you, they win, right? They win it and they get a judgment. Maybe they try to collect from you for a year or two, and they're just like, we want to get out of this business. And they'll sell judgments for 10, 20, 30 cents on the dollar because person has the lien rights. So every now and then you'll see, notice a new party of interest that gets filed in a case that has a judgment that was entered 5, 6, 7 years ago. And that's what's happened. They've sold that judgment. So that happens sometimes. But yeah, I mean, it happens more. I mean, we see the legal part of it, and it's kind of changed because you have attorneys like myself and my firm that fought back enough where they used to sell it 3, 4, 5 times before suit. Now, most of the time, I'd probably say 90% of the time, it's maybe changed hands once, and the other 10% maybe twice.
Okay.
Because they just don't once a judge at a certain point go, okay, you're the 5th person that's touched this. You don't know anything about the original company or what happened. At a certain point, it just gets too flimsy, and there's a lot more judges that won't hold up the records on those type of cases.
Brian, do you want to give your firm information one more time so everybody can give you a call?
Yeah, of course. Our firm is called We Protect Consumers. If you have a credit card or any kind of bad debt kind of issue, you can call us at 1-800-813-6086. You can reach out to us at e-file at We Protect Consumers. Obviously, we have a Facebook page, and we also have a web page at weprotectconsumers.com. We'd be more than happy to talk to you for free for 10, 15, 20 minutes, whether we can help you or not, give you some general information how you may want to attack your debt issues.
Sounds good.
All right, everybody. This has been another episode of the Drinking with Drew show. Stay tuned for more uploads, more shows. Follow us on Instagram, Twitter, Facebook, Humble Social, all the socials. Our live shows are Tuesday at 6:30 Eastern Standard Time. Feel free to check us out live. You can call into the show and be a part of it. See you soon.